Okay.
Hey, welcome everyone to this new episode of our podcast of Legal for Tech. If it's the first time you actually connect to our podcast, we are a group of students, of friends who are very interested in all that's about law and technology. And today we have the immense pleasure of having as a guest Gianclaudio Malgieri. For Italian speakers, Gianclaudio Malgieri. He is an associate professor of law at Leiden University, and he's here to talk about his recently written book, but also his experience, his career. I will be joined in this podcast by my colleagues, Giacomo Di Gregorio and Giacomo Amodio. Say hi, Giacomos.
Hello, hello.
Hello, everyone.
They're here. I can see that. Going back to our explanation. Dr. Malgieri, let me quickly ask you. So you have a fascinating career that bridges academia, legal practice, and policy work in the fields of privacy and, of course, data protection. Would you mind sharing with us a bit about your journey, what inspired your deep interest in this intersection between law, technology, and, of course, very importantly, human rights?
Sure. Thank you very much for having me here. I'm very, very happy to talk to all of you. Yes, I would say that my first trigger was the interest for law and technology, for the regulation of technology. 12 years ago, the topic was already rising. There were different keywords, and it's very fascinating to see how keywords have changed. At the time, we just talked about cloud, then big data, then AI, and now it's generative AI. So I don't know what will be the next keyword. So as you said, I am now at Leiden University. I teach here. I'm an associate professor of law and technology, but I teach fundamental rights in digital technologies, but also privacy and data protection. I have also in my not so free time parallel job as co-director of the Brussels Privacy Hub in Brussels, and that helps me also to have a view on the policy issues in the European bubble, the Brussels bubble. In particular, I followed a lot the AI Act, but I'm also following parallel proposals like the AI Liability Directive, or I was following a lot the Digital Services Act. Before joining Leiden, I was so I'm doing it from like backwards. I was in France. I was teaching in a business school, the EDEC business school in Lille. So still not far from Brussels. I cannot really live far from Brussels in general.
You may not be the only one, I'm told, about the two Giacomos that are here who are
Yeah.
actually established in Brussels as
I think
well.
because you love the weather at this point, Gianclaudio, huh? Yeah, I'm also, how to say, appreciating more the Brussels weather being in the Netherlands, which is worse because in the
Okay.
Netherlands even worse weather. By the way, before that, I did my PhD at Vrije Universiteit Brussels in Brussels. So yeah, that's a bit what my story. I also help the European Commission as an expert for ethics evaluation of research projects. So I'm an external
Wow.
for research executive agencies. It's a fascinating application of our topic in a very practical way and also abstract way. Yes, and maybe just to say, scholars need to have always a view on publishing and publishers. And so I'm also managing editor of Computer Law Security Review, because it's also important for scholars to have a view on what's happening in academic journals. But this is another chapter we don't want to open now, I guess.
Well, that's good material for a future interview, maybe. Um, I'm booking you in. Yeah, I mean, the keywords you mentioned, I mean, I hope that the next one is not going to be killer robots. That would be very interesting. And also, it's a good bridge for my next question, because talking about things that could be dangerous, your next book, I mean, recently written book, actually, very influential in the field. It's called Vulnerability and Data Protection, talking about dangerous things. So this book challenges the traditional notion of vulnerability by including new subgroups of data subjects. Now, this is all very difficult. So could you please elaborate a bit how digital media has, in your opinion, reshaped our understanding of the word and the concept of vulnerability?
Yeah, thank you so much for this question. And actually, you said your next book, which is also not so false, because my next book will be explaining more about AI and vulnerability. But yeah, my previous book, indeed,
Booking
it's
you in again.
So basically, yeah, I was trying to interpret the national vulnerability in the GDPR. So we all know that the General Data Protection Regulation is full of so many different references. It's a huge text. And Control F, vulnerability appears just one. So if we look for vulnerability in the text, we just find one reference, which is vulnerable data subjects, especially children, in a recital, so in the preamble of the law. And you might say, have you really built your own PhD and one book for Oxford University Press on a recital of the GDPR? So I would say yes, but that was the challenge. So I think in law, we have already an important scholarship and development in terms of consumer vulnerability. The concept of consumer vulnerability has been there since 2005. So it's now almost 20-year old, but in data protection, we never had something as vulnerable data subjects. So it's now mentioned in the risk factors for data protection impact assessments. We know that for higher risk data processing activities, we have to do a data protection impact assessments if we are a data controller. But for some of them, we need to check what are the risk factors. One risk factors is having vulnerable data subjects, especially children. So I would say especially children means that there might be other groups of vulnerable data subjects. My challenge was a bit to discover who they are. And there was an easy trap in this exercise, the trap of just looking at groups as silos. So, you are vulnerable as a group, you are vulnerable as a group, and you label them, right? This is problematic. A lot of gender scholars, queer scholars, feminist scholars in the past fought a lot against this. We cannot just consider groups as vulnerable. So my challenge was a bit to look at context. What is the context of vulnerability? So when they ask me who is vulnerable, I always change the question in vulnerable who, but no, it's vulnerable to what? Vulnerable when? Vulnerable towards whom? So this is just in a nutshell, but we can go deeper if you want.
We will go further in the topic because I feel like there's a question from Giacomo. Do you have a
Yeah,
question?
you mentioned that the GDPR provides forward-looking tools for addressing vulnerabilities. Could you give some example of these tools and explain why they remain unexplored?
Yeah, so I think again, if we look at what vulnerability means, I think in the GDPR especially, vulnerability is the consequence of power imbalance between the data subject and the data controller. And this can be exported to other fields beyond data protection. So for example, AI deployer and AI end users, they also have a power imbalance. This power imbalance can be seen, for example, in traditional asymmetric structures. For example, the relationship between employer and employee, the relationship between a trader and customers. But with and we can make more example: public administration and citizens, border control officers and migrants. There are many examples we can do in the digital technologies and in intense data processing activities. This vulnerability power imbalance is really evident with many aspects, in particular digital illiteracy, but also the big dependency that we have today on big techs. So our dependency, which is the basis of what Marta Feynman defines, the mother of a legal vulnerability, defined as a concept of vulnerability. Our dependency makes us inextricably linked to these technologies. We cannot live without them, but at the same time, our fundamental rights is really at odds in living with them. So the point, how the GDPR can help us. So I think also without changing the law, the GDPR can already do a lot. And in the book, I try to explain how principles, fairness principle can help to mitigate power imbalances. If we really apply the fairness principle seriously, not just as a meta concept, but as a real principle, applying fairness means that, for example, payer consent wouldn't be really possible. For example, just to make an example that is a very hot topic now, or data protection rights, they should be personalized, at least looking at the needs of special groups in that in special context, special power imbalance relationship, special interpersonal conditions. Transparency, for example, also. Transparency should be tailored on the specific needs of specific data subjects at issue. So I think in a nutshell, interpreting the GDPR in a vulnerability-aware way means to understand that many data processing activities cannot even start in certain situations, that many lawful bases cannot even be considered in certain situations, like consent, for example, should not be abused so much. And of course, transparency and other rights like fairness principles should be considered in specific context.
It's very interesting that you talked about it, a meta concept. You mentioned meta. That is very, very peculiar that that word specifically came up to your mind, I would say. Very nice. I think my colleague Giacomo Di Gregorio has a question for you because you talked about vulnerability aware interpretation of the GDPR. But I think he knows something a bit more specific about cognitive vulnerabilities. Do you know something about that, Giacomo?
Yeah, I wanted to ask exactly that. Like, in your view, what does vulnerability-aware interpretation of the GDPR look like in practice, and how it could transform data protection practices?
Yeah. So I think in general, the GDPR has many layers of interpretations, right? For the first 8 years, we have seen a very minimalistic interpretation of some concepts. For example, data protection impact assessment, such a powerful tool, such an underestimated tool. So data protection impact assessment is really a powerful GDPR tool that is now reduced to cybersecurity checks and like questionnaire. It's not really a tool expressing its potentialities for as it is now. But we had to wait the enforcement, like data protection authorities that could enforce the poor implementation of impact assessments. Why am I emphasizing now so much on impact assessment? I didn't mention it before, and I'm emphasizing it now because impact assessments are, as I told before, we need to consider higher risks data processing. And what is vulnerability, if not a higher risk to our fundamental rights when our data are processed? So basically, impact assessment is also a vulnerability assessment. It's kind of inherently a synonym because we need to consider higher risk and what is the impact in terms of severity and likelihood. So impact assessment is also a way to deal with vulnerability. And then, so I think a vulnerability-aware interpretation of GDPR means to really take into serious account all the accountability principles I mentioned already, fairness and transparency. I mentioned lawfulness. I mentioned data protection rights. I mentioned right to access, for example. But all these things should be considered in an impact assessment. So before we start with certain activities, with certain technologies, we should wonder what will be the impact on some groups? What will be the impact on certain power relationships, right? And so we can make many examples. I'm sure children is a first example coming to our mind. but there are others, right? Like, for example, you were mentioning cognitive vulnerabilities. So, people with problems in understanding privacy policies, people with problems in taking decisions because they are addicted to certain digital services. And addiction cannot make us free. And addiction is a problem that also data controllers and tech companies should address. We shouldn't wait just the states to take actions. I think it's already in impact assessment, since we have to mitigate risk to fundamental rights, this is something that should be considered.
Dr. Malgieri, sorry to ask, but this question just came up to my mind. When you said that there are people that could be vulnerable because they are addicted to the online experience they are facing, I mean, of course, that is supposedly the purpose of a social network, isn't it? To get people addicted to it. How would you measure addictiveness?
Yeah, thank you. Great question. We are trying to do that now with a team of colleagues here. We have a project called Resocial. The full name is Resilience and Vulnerability on Social Media and the Metaverse. The project is funded by the Dutch Research Council, and I'm leading it since this year. And we are trying exactly to measure that. So how to measure dependency. And the topic of measurability is philosophically very, very complex in the fundamental rights discussion, because can we really measure impacts on fundamental rights, like in terms of quantification, right? We have this other big problem in the GDPR interpretation. What is a risk to fundamental rights? Is this something that we can measure with numbers or not? And we see two great groups of scholars fighting with each other, because some say, yes, we should apply business management risk analysis, and others say, no, fundamental rights are immoral boundaries. It's impossible to measure something that is a moral boundary, like a philosophical humanistic concept. Going back to your question, how can we check addiction? So first of all, addiction is a medical term, and so there are other digital scholars suggesting other terms like compulsive use or abuse or whatever. I think addiction still, or dependency in general, which is a broader concept. I would say, so we are trying now with some social scientists and human-computer interactionists, together with lawyers, to work together as at a measurement of addiction, even qualitative measurement, which means not numbers, but at least we try to understand priorities. And yeah, of course, time spent on social media is one factor. But another qualitative factor that we are asking to data subjects is, why haven't you ever considered to delete your profile from social media? What is the alternatives that you feel? Why you keep being there, even if you feel that maybe you don't want to give your data to social media? Why you don't pay, but you give your consent, and your consent is not free, but why you keep being there? So these kind of questions are helping us to measure more the concept of dependency. And of course, it's not easy. It's not a black and white question. There are many nuances, and there are many people that can just say, "Oh, I'm fully free. I want to be part of this." But
I mean, talking about nuances, I mean, this is basically the definition of human rights, isn't it? I feel like it's really difficult to talk about human rights in this field, because we're talking about technology after all. Giacomo, what do you think about that?
Yeah, I want to focus on that a bit more, and I would like to know, how would you reconcile, for example, the evolving landscape of human rights with the rapid advancement of technology, especially in the context of privacy and data protection?
Yeah, so I think this question is super important, and we should be a bit creative. We shouldn't just stick to the traditional ways, because the traditional ways of applying human rights horizontally, and fundamental rights horizontally, so asking companies to apply, and in particular tech companies, to apply human right and fundamental right, is important. It's also something quite new, because we see fundamental rights impact assessment in the AI Act. The AI Act has 4 different levels of risk assessment. You have the generative AI for systemic risk assessment, then you have the deployers FRIA, then you have the providers risk assessment Article 9, but 2, because there's also Annex 4. I don't want to go with numbers again, but just to say this.
Again, ladies and gentlemen, stay with us because the next interview is going to be on the AI Act. You can bet it.
I'm bridging here. And then in the DSA, you have risk assessment, which is also a fundamental right impact assessment. So you have many things, right? But the point is it enough? Is it if we don't have a methodology to develop them? So just to answer with some bits of creativity, I think we should go in in an additional directive, which is complementary, which is participatory design, participatory impact assessment, inclusive co-design, and empathy in relationship with vulnerable data subjects, with data subject in a condition of vulnerability. So participation, what does participation mean? Can we really assess the impact of fundamental rights without the views of the impacted stakeholders? Can we really understand the severity of impact without understanding how different groups perceive the severity of violation to fundamental rights? Since we said it's not a black and white exercise, it's not a purely numerical exercise, we need to understand contextually how different groups in a situation of power imbalance, for example, teenagers using TikTok, just to make an example, or foreigners using a public administration tax app, so app for the...
Not to evade taxes, of course.
Exactly, and having always been a foreigner, because I've left Italy almost 10 years ago, I've always experienced this vulnerability. And so the point is, what is the next step? The next step might be participation, and participation how? So we need intermediaries. We need some groups representing us, representing the position of vulnerability, right? The Data Governance Act suggests one possibility, which is the data cooperatives. It's a word that is dropped there. Nobody knows it. Nobody is trying to understand how they work, but the definition is powerful. Data cooperatives are a group of data subjects that can represent the interests of data subjects in negotiations for terms and conditions and consent conditions, which is so powerful, so strong. If you consider the possibility to rebalance power imbalances on a negotiation level. I'm just mentioning one thing. And then I mentioned empathy. I think I should also explain it in 1 minute. Empathy is now considered as a new tool, also to break, and now I'm playing a bit as a critical legal scholar, to break the masculinity in the law. The law has been always patriarchal and based on some concepts and snobbing other concepts. Love, care, empathy were considered feminine concepts. Judith Butler did this analysis, and we're
very proud of being associated with these things. Like, honestly, go girls.
Exactly, and the law has always snobbed them. Why don't we put empathy in the law? And of course, empathy is difficult to apply in a one-to-one, to impose, to be imposed. It's very difficult that you can impose empathy, but you can impose certain steps towards empathy. So it means that the data controller or the AI deployer should be imposed certain inclusive design, inclusive impact assessment, and inclusive practices to understand emotions and needs of the other party. It doesn't mean collect more emotion, because I already see the reason collecting more.
They have enough of our emotions.
It just came up in my mind that this is similar to the legal by design approach. When you need to create like new privacy policy, you take into account what are the views of the data subject.
Totally. I agree with that. And by design approach, I think, again, has great potentials, but the application was kind of limited. Why? Let's start from privacy by design, the most famous concept. Anne Cavoukian in Canada invented the term, and then the GDPR 4 years later took it as privacy by design and data protection by design, DPBBD. DPBD, sorry. And how has it been applied so far? Let's look at the definition of data protection by design. Data protection principles should be considered in the technical and organizational measures of the data processing activity. How it is being interpreted in practice? More anonymization, more pseudonymization, more data minimization. But they never consider more fairness, more law, right? So everything was just privacy in terms of anonymization. So they invented PET, privacy enhancing technologies, very powerful ones. Differential privacy, synthetic data, very powerful technologies. But they don't solve the fairness problem because they represent the majority. In order to be data minimal, you cannot represent diversity. So vulnerable groups, marginalized groups, are never under the spot, are never under the radar. So what I want to say is that the by design concept is extremely powerful because very often it's too late. Sometimes it's too late to regulate. If we had to really block ChatGPT, TikTok, character AI today, it would be too late. People are already addicted and dependent. What we need is to consider principles like fairness and power imbalance in the design and not just data minimization, because data minimization can be done by cybersecurity people. Fairness needs to be done by social scientists and lawyers. So,
but Professor, let me play devil's advocate here for once. It's not my usual kind of role. Say I'm a firm, I'm Meta, I'm LinkedIn, and this speech is amazing. It's beautiful to hear. But I mean, what do I care for fairness? People are still consuming my social network. Why should I care?
Exactly. And indeed, the enforcement authorities, like the data protection authorities for data protection, the European Commission for the DMA, and relevant authorities for the DSA that change from country to country, and relevant authorities for the AI Act that are a mess, but should give sanctions if you prove that you didn't respect the fairness principle, if you abused of power imbalance. Okay, so if you cannot prove that you did as much as you could to reduce adverse impacts on fundamental rights, including mental health of your data subjects, in my view, you are violating the GDPR. And I say it loudly, I mean, we should all say that. The GDPR is a tool to protect all fundamental rights when our data are processed, right? And you might say, yes, but the regulators didn't do much in this direction. Yes, but something was already done. I just mentioned one case. The DSA enforcement team of the European Commission, DG Connect, as you might know, some months ago, opened a case against TikTok for the addictive videos in Spain, Italy, and France, I guess. So there was this new addictive, like personalized video feature. And they didn't use prohibition of dark patterns. They didn't use manipulation prohibition. They used, as a principle to start the procedure, a poor impact assessment. So also in the GDPR would be poor DPIA and poor fairness principle. So they used a violation of an accountability duty to start the procedure. I'm just saying that this brings me optimism because it means that now there's high scrutiny on how big techs are assessing the impact on individuals. And this is thanks to 5 years in which we had the approval of the Digital Services Act, of the Digital Markets Act, of the AI Act, complementing the GDPR. So I'm proud to be European for that. Let's see how it will work in the future.
This is very beautiful. You're talking about a fairer Europe, but is it an innovative enough Europe? This is a big, huge question, and which I will leave definitely our followers with, and potentially that you will come back to us to talk about and discuss in the future. But before you leave us, I shall thank you very, very much for your presence here. But I would like for you to just tell us one more little tip. Do you have anything, any suggestion, any book, any podcast apart from ours, which you shall of course mention? Let's make this clear. Or maybe a TV series that you really think shows the impact of everything you've been researching on, what shall we do in our free time to understand your research?
Sure. Documentaries on the topic of addiction and digital media on Netflix and on other platforms are many, and it's a bit of a paradox because also these platforms are also addictive. Something I found extremely interesting in terms of podcasts was Land of the Giants. I don't know if you know that, but it's based on every season has a different scope, a different approach. Specific big techs. So you have the first on porn industries, then you have social media with the focus on Facebook or search engines, and it analyzes these aspects going very, very deeply. Then, of course, I would suggest Social Dilemma. I think you also know it.
Yeah, that's a hit. That's a hit.
Absolutely.
And I always use the trailer for my students just to give them a full immersion on the topic. And there are many books that are extremely relevant for the topic. I think one recent book that is really interesting and was published just a few months ago is The Tech Coup by Marietje Schaake. She's now at Stanford, but she used to be a member of the European Parliament from 2009 to 2019. So she has great experience on how to regulate social media. And she wrote this new book about how the power of big tech is jeopardizing democracy. So yeah, a lot to read.
Professor, I can see that you are very delicate because I shall do it for you. Let's plug in your book again, Vulnerability and Data Protection by Professor Gianclaudio Malgieri, who came today to talk to us. Thank you very much, Professor. I shall thank my colleagues as well, Giacomo Amodio.
Thank you very much.
Thank you, Gianclaudio.
And Giacomo Di Gregorio. And yeah, follow us for more. Don't think that following us on LinkedIn is addictive. It's actually very helpful, I can assure you. So don't stop following us. Please tap that like button and see you again. Bye.
Bye.
Bye.